Good morning, good evening, good afternoon. Happy Thursday. Today is a California court holiday, but it's not a federal court holiday. So Chili's day 4 is going to be today. Day 3 was somewhat interesting. Day 3 was Chili's first day to testify. In the middle of the day, after lunch, after Chili had been testifying for a very short period of time, the LVMPD, the defendants, moved for a mistrial. Now, why would they have moved for a mistrial? Well, there was a motion in limine that was granted in part. I don't know the exact part that was granted in part, but the motion in limine was to exclude evidence of the detention after arrest, exclude evidence of the trial after arrest, to exclude evidence of the appeal after arrest. And that motion in limine was granted in part. A motion in limine is just a pre-trial motion made, generally speaking, just a few days before trial. Sometimes it's heard the morning of trial. And it is a motion to exclude certain kinds of evidence. And you have to have a valid legal reason to exclude the evidence. Most likely, in this case, it was more prejudicial than probative, and it didn't go to any of the underlying facts for any of the charges that he was being presented with. And that was granted in part. I don't know which part was granted, which part wasn't, but my basic assumption is that Chili testifying about the appeal is one of the things that was excluded. Now, why would that be more prejudicial than probative? Well, because at the criminal trial, the state had the burden to show beyond a reasonable doubt, it's a very high standard, beyond a reasonable doubt, that all of the elements of the crime were committed by Chili, and that there wasn't a defense to the crime, a defense. They did not prove that beyond a reasonable doubt. That's what the appeal says. The appeal says that, he had a First Amendment right to do it, and Officer Bork was what basically the interference that Officer Bork made the arrest over was First Amendment protected activity. But what the court is actually saying by that is that the state at the criminal trial didn't prove beyond a reasonable doubt that it wasn't. That's really what it's saying. It doesn't go to probable cause, and probable cause may come into play for the false arrest, Nevada County, or the Nevada State false arrest cause of action that has been incorporated into this. The federal wrongful arrest, 1983, that's been disposed of. But the important thing for the layman to remember is that probable cause is a much lower standard that the state had to prove at the criminal trial. And the state proved it multiple times. The state proved it at the probable cause hearing. The prosecutor thought there was probable cause, or else the prosecutor wouldn't have gone through with the case. At the trial court found, if the trial court had found there was no probable cause, the trial court would have found Chili to be not guilty based on a lack of probable cause. The court didn't find that. The court found that, in fact, not only was there probable cause, but it was beyond a reasonable doubt. So there's been at least 3 kind of filtering layers to suggest that the cops' assumption that there was probable cause, in fact, means there's probable cause. But remember, you can make mistakes of fact and law as a cop and still succeed, because there's several cases that dealt with it. There's one case, I can't remember the name of it, that went to the Supreme Court, where the driver had one taillight out, and the state trooper misunderstood the law and thought you had to have 2 operational taillights, and if one was out, then it was a valid stop. And the state statute actually only requires 1 working taillight, 1 working brake light. But the officer made a reasonable mistake of law, right? So the officer can make a reasonable mistake of fact or a reasonable mistake of law and still have like reasonable probable cause, right? It's just such a low burden that almost certainly the cop had probable cause. But the judges, or the appeal to they appealed to the district court, I think, in Nevada, which is a pretty low level. It's not their court of appeals or their Supreme Court. That appeal, number one, it doesn't carry any weight in the federal proceeding. The cops get to show they had probable cause again, so regardless of anything, but they will probably be able to show probable cause, or at least reasonable probable cause, if that makes sense. So, but that was most likely excluded. Chili and his attorney, in their infinite wisdom, decided to talk about it anyway. The court most likely, it appears the court did not grant the motion for mistrial. The court may have either denied it outright or reserved on it, basically saying, I'm not going to decide this right now. I'm going to decide it further down the line. You know, if Chili keeps doing it, then I'll grant the motion for mistrial. He probably admonished Chili not to talk about it. He probably admonished the jury to disregard it. He probably had it struck from the transcript that the jury will be able to see at the end of it, if they, during their deliberations. I've never practiced in this Nevada District Court, but generally speaking, the judge will allow the jury to see a transcript of the testimony to assist them in their deliberations, as well as give them copies of all the exhibits that have been entered into evidence. So there's a high likelihood that this won't taint the jury, and that's probably why the judge didn't grant the motion to dismiss, or motion for mistrial, at least not outright. But again, there's also, I mean, they could raise it again if Chili starts, even if the judge didn't reserve on it, the defendants can raise that motion again if Chili again testifies about things that he's not supposed to testify about. You know, the motions in limine are there for a reason, and it's not good practice to bring things into evidence that have been already ruled on as inadmissible by the court. I mean, it's just, I mean, I get trying to taint juries. You can't unring a bell, but it might, you know, Chili keeps talking about an appeal, and one of the issues now that the defense has preserved for appeal is whether or not the motion for mistrial should have been granted. So Chili's giving the defendants more things to appeal on that actually have substance, and I haven't heard anything from Chili that makes me think that he has any substantive grounds for appeal that I'm aware of, at least as far as the trial is concerned. Maybe he could appeal on pretrial motions that were denied or whatever, but I haven't seen anything substantively that really Chili has a good shot of appealing. Chili gave mixed messages. I did see one where he was talking about how he still anticipates losing, and you only really win on appeal. Well, generally speaking, that is not the case. I get it that Chili's all hopped up on hopium because he won his appeal in the criminal matter, but I give very low odds on appeal normally, and on that criminal matter, I think I gave like a 1 in 3 shot of him winning, which is pretty high odds on appeal. Generally speaking, your odds on appeal are very, very low. And that's with competent counsel filing the appeal based on what they believe to be a mistake of law that the judges have made. So, you've got competent counsel thinking, I have a shot at appeal, not Chili Decastro, who doesn't know shit from fuck. And even then, with competent counsel saying, we've got a shot at this, there's still a very low chance of success on appeal. So, again, it's, don't bank on winning on appeal. So we'll see what goes on today. Again, they're going to be back in trial today. Again, I wish Chili the best of luck. I wish Michael Mee, Chili's attorney, the best of luck. Because, it sucks. It sucks when your client doesn't accept a reasonable settlement offer and instead drags you through. I mean, the plaintiff hasn't rested yet, so who knows how long the defense is going to take. And we're on day 4, and Chili's still testifying. So we'll, Michael Mee's in my prayers. Poor dude. It sucks to be put in that position by a client, but whatever. Maybe he'll strike it rich. Maybe the jury will actually rule in Decastro's favor, and And who knows how well the officers testified at trial. Who knows how well Chili's testifying. Chili seems to think that he testified amazingly. And, I've seen Chili in court before, so I tend to doubt it, but I haven't seen how he did this time. Maybe Michael Mee coached him excellently, and maybe Chili's following all of Michael Mee's instructions and presenting himself well. Again, I hope, I don't have any ill will towards Chili. I don't have any real expectation he's going to win, but, good luck to you, dude. Good luck to you. Anyway, that's all I got for today. Thanks for watching. Have a great day.